Hi, good night. This is U.S. Immigration Attorney Sharifa Tharp. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. So I'm going to be talking about the different stages of the adjustment of status process as well as the consular processing to let you know the differences between those processes. And if it's the first time you're hearing about these types of processes, I'm going to explain what these processes are. Hi there, a new revenge. Now let's start with adjustment of status. So everybody wants adjustment of status, especially if you're already here. Adjustment of status is the process of applying for permanent residence while you are already here in the United States. And so it allows convenience because you don't have to leave, especially if you've been here for a while without status and you don't want to face the prospect of being stuck outside of the United States. You would be able to stay. Thanks so much for the love. You'll be able to stay and, be unified with your family or your spouse while you go through the process. In addition to that, adjustment of status offers a great benefit. It offers you the ability to work while your process is going forward. So about 6 to 8 months after applying for the adjustment of status, as long as you've applied for the work permit, then you'd get that work permit 6 to 8 months afterwards, and then you'd be able to work throughout that time. And it's a 2-year work permit. The reason it's now a 2-year work permit is because the processing times are taking longer. It's taking 18 to 24 months. And so to allow more convenience for immigrants who have work permits, they are now allowing them to renew it 2 years instead of every year, because that can get stressful, especially when time runs out and it's taking long for that work permit to come back. So that is what adjustment of status does. However, here's the tricky part, is that not everyone who's here that qualifies for the permanent residence is going to qualify for adjustment of status. So BJ pumping, keep in mind that the information here I'm giving you is general information. And so if you are experiencing a different time, it's going to be based on the service center. It's going to be based on what's going on in your case personally. What I'm giving you here is general information. So it is not like math that's going to be precise, right? Processing times are going to change just depending on what you're going through. What you can do to get a more accurate range of time that your work permit is going to take is to go to uscis.gov, go to case processing times, scroll down a little more on the page. You'll see case processing times. Look at the service center that's processing your application, your work permit application, and see if 8 months is within the range of time that they're taking, or if you're outside of that range of time. However, the average that I see in my practice is 6 to 8 months. So, as I was saying before, now when you're applying for adjustment of status, it's going to allow you to apply for the work permit. It's going to allow, and it's a 2-year work permit. It's going to allow you to apply for the travel document, and at the same time, and it's going to allow you to submit the petition. What's happening there is that your qualifying relative, or your spouse who is applying for you to get permanent residence, is going to apply jointly with you. So they're going to submit what's called the I-130 form, the I-485 form, and additional forms just depending on what type of application you're submitting. The adjustment of status form with the required evidence to go along with it, the work permit and the travel document. So it's a lot that you have, a lot of moving parts to it that you have to make sure is precise, and make sure everything looks good to go. Now, once you have prepared that application and you submit it, the next is a biometrics appointment, or right now, for those who already have biometrics appointments, they're submitting a reuse biometrics notice. That means that they're just issuing you notice that they're not going to call you for a biometrics appointment. They're going to reuse your old one. So some people are getting that if they previously filed. And then after that, the work permit comes some months after that. Biometrics appointments are taking 3 to 4 months, I'm seeing. And work permits an average of 6 to 8 months. And it usually comes after your background check is done. So after the background check, then the work permit. Then after that, you are going to wait as long as you haven't received anything else, like a request for evidence. You are going to wait for that final interview to be scheduled. So the final thing that you would have to wait for is that interview to be scheduled. Also keep in mind that there's the medical examination. So the medical examination is required. However, you do have the option of applying for the medical examination. When you're submitting the application, you submit the finished medical examination with the application. You submit it during the process. While the process is pending, you can then go do your medical and submit it afterwards. Or you can wait until your final interview where you can take the medical in with you. The reason that sometimes or previously I recommended to my clients that they do the medical right before the interview is because the medical, it was taking a year to expire. And so processing times have been getting longer and longer. And because of that, the medical examination would expire and they would have to pay all over again for a medical examination to be done. So to avoid the additional expense, I'd advise my clients to do the medical right before the interview. However, they have now extended the validity period of the medical to 4 years. And what that means is that it is, it's highly unlikely that your process is going to last 4 years. So once you do the medical, you are likely safe with submitting the medical and being reassured that it will still be valid at the time that you attend the interview. So let's look at some questions. So wife is U.S. citizen. Both of us live outside of the U.S. She has unconditional landing for the country we live. How does that impact the process if we both want to move to the U.S.? So in order to apply for a spouse, and if you're outside of the United States, you'll have to show that you have domicile in the United States as a U.S. citizen. That means that in some way you are living or maintaining a residence in the United States. So if your wife has been outside of the United States and she absolutely has not been maintaining any kind of ties to the U.S. or domicile, then that could potentially raise an issue during the process. Now, Xerxes, if you and your wife would like guidance throughout the process, schedule a consultation and we can talk more about your particular circumstances. You can go to the link in my bio. It's going to take you to the website where you can then contact the scheduling coordinator through the form, through the online chat, or through the phone. She's available up until 11 p.m. tonight to assist you and get you on my calendar. So once your medical is done, once your all your paperwork is done, you've received your work permit, all looks well, then the final stage is the interview. You will, if this is marriage-based, you'll attend with your spouse and you'll likely get questions based on the marriage. Or if it's another type of relationship, if it's based on the employer or based on your based on other family members, then the line of questioning is going to be related to your relationship, to make sure you qualify for adjustment of status, and to make sure that you qualify in every way to get permanent resident. Now, I had mentioned before that not everyone who qualifies for permanent residence, even if you're here, is going to qualify for adjustment of status. So that's one of the where you have to be very careful. You have to make sure you qualify. So usually it's individuals who are maintaining legal status already. So that means, for example, you're here already on an employment-based visa, and that employment-based visa is going to last for the entire time you're here. Or if you're out of status, that you fit within the exceptions to that rule. Exceptions to that rule is if you're the immediate relative of a U.S. citizen. Now, immediate relatives of U.S. citizens still doesn't mean everybody. Then it narrows it down further to spouse of a U.S. citizen, parent of a U.S. citizen who is 21 and up, child of a U.S. citizen who is under 21 and unmarried. And on top of that, if you fall within this category, that you also came into the country with permission. If you don't fall within this category, then another exception is going to have to apply, and that's going to be VAWA. So if you're being mistreated by a U.S. citizen or legal permanent resident spouse or parent, if you're under 21, under 25 in some cases, or a U.S. citizen son or daughter who's 21 and up, then this could be a path for you, even if you came into the country without permission in some cases, and even if you're out of status. It's called VAWA. So, Alessandra, can someone get a divorce when they are in two different countries? So yes, however, that is not my field. I'm not a divorce attorney. I only deal with immigration issues. And so you have to ask an attorney about that, especially now it goes into international family law issues. You're welcome, Xerxes. So I'm here in the U.S. on a visiting visa. However, I was offered permanent employment here. How can I apply for a work permit? So Shenji, the employer would have to be the one that applies for you to get your employment-based visa, employment green card, or you'd have to qualify in some other way through a family member. But that's what I wanted to let you know. Also, I like to remind everyone here that the work permit is not just a freestanding application that you can come here on a visitor's visa and then apply for a work permit. Unfortunately, it doesn't work that way. A work permit is reserved for individuals who qualify for a benefit or relief already in the United States, and so they can apply for the work permit at the same time while their application is pending. But coming here on a visitor's visa and then applying for a work permit is a definite no-no. Actually, it would indicate that you have an intention to come to the United States and work, and that could be a big problem for your visitor's visa. So you would have to speak with your employer who is giving you this permanent employment to see if they would want to look into pursuing sponsoring you for either permanent residence if you qualify, or an employment-based visa. The employer can always schedule a consultation, and then we can talk to the employer. And I'm saying the employer here because it would have to be the employer that sponsors you. And so when I go through the employment-based process, I represent the employer through the process. And so you can definitely speak with your employer and see if that's something they're willing to do. Okay, so Youthful 40, I'm here, can't find you on TikTok. So that's okay, because guess what? Most of my content is here on Instagram. So Youthful 40, you can stay with me here on Instagram, and that is great. Now, and that's because I'm mostly on Instagram. Most of my content is on Instagram. Most of my updates are on Instagram. But I also have a YouTube channel where I do longer videos, and I also repost my lives on TikTok on the YouTube channel, and I talk at length about different processes on YouTube, because YouTube is a platform where I can do that. So I am the immigration attorney, same name as here on Instagram, on YouTube. So you can catch me here, or you can catch me on Facebook. I am ST Law Office on Facebook. So I'm on all sorts of different platforms. You are free to follow me here, but you can also, my content differs just based on the platform I'm on. And so on YouTube, you'll find longer videos, more detailed videos about specific immigration topics. So great questions so far. Keep your questions coming. That is why I am here to answer your immigration related questions. So put those questions in the comments. I have been talking about the adjustment of status process and the consular process. If you don't know what those are, I'm explaining it right now. Adjustment of status is the process of applying for permanent residence while you're in the United States, meaning you don't need to leave. You can actually even apply for a work permit while you wait for your process to be pending. But keep in mind that just coming here without any qualifications to apply or eligibility to apply for adjustment of status is not going to qualify you to apply for a work permit. Unfortunately, work permits don't work that way. Now, let's talk about adjustment of status, right? Because I talked about who is eligible. The main rule is, if to qualify for adjustment of status, you have to be maintaining legal status, or you have to fall within an exception. You have to be the immediate relative of a U.S. citizen. You have to be a VAWA applicant. You have to be a T or U visa holder, or have asylum. So those are the main ways that you could possibly qualify for adjustment of status, assuming you don't have any other disqualifying issues going on. Those are going to be the main ways. Now, if you don't qualify for adjustment of status, that likely means that you're going to have to go outside of the United States. You're going to have to attend an interview at the embassy in your country, or in some cases in a country of your choosing, to be able to get the permanent resident. Now, I know for some who are here, the next question is, well, I'm here, I don't have status. If I don't qualify for adjustment of status, what am I gonna do? And so I talk often about this in videos. The videos are really short snippets, and so this is where I want to talk about this in a little bit more detail. So if you're here, you don't qualify for adjustment of status because you don't fit within any of those categories that I just listed, then the next thing is to determine whether you can qualify for a waiver. I like to say to get forgiveness for a visa overstay. And once you get the forgiveness for the visa overstay, then once you can stay here while your waiver is pending. When you get a decision, then you can wait. You can go to the interview when it is scheduled. You can wait in the U.S. until your interview is scheduled, and then fly to your interview, or go to the interview in the country with the embassy and attend your interview there. What's going to happen is that the officer once they see the approved waiver, they are not going to penalize you or deny you based on the overstay. What they will do is just make sure you qualify in every other way, and all being well, you do, then you get to come back after about 2 weeks after they process you for your immigrant visa. Then you get to come back to the United States and be unified with your family. So that is the way to fix your status if you don't qualify for adjustment of status and you're already here in the U.S. and you're out of status. Now, to qualify for the waiver, just as I said with qualifying for adjustment of status, not everyone who qualifies for permanent residence is going to qualify for adjustment of status. And the waiver is similar in that not everyone who has overstayed that is here in the US is going to qualify for a waiver. The waiver is for individuals who have a US citizen or legal permanent resident, spouse or parent who will experience extreme hardship if you don't get the green card. So that is going to be the way that you're going to determine whether you qualify for this waiver. And that's where, of course, the consultation is going to come in. I can help to evaluate your circumstances in detail because it all comes down to the details in your case to determine whether you qualify for this type of waiver. And you can always do that by contacting the office through the link in my bio and schedule a consultation. There is a scheduling coordinator who is available up until 11 p.m. tonight to schedule you. Now, let's talk about consular processing. That's the process where your relative is outside of the United States or they don't qualify for adjustment of status. What does that process look like? So the first part of the process is that you apply for you as the relative, you apply for the petition. And once the petition goes through the processing, then it goes to the National Visa Center that processes your paperwork. Then it goes to the embassy, and that's where they call you to schedule. They send the appointment notice for you to attend the interview at the embassy. All right, so let's look at some questions again. Do some apply for adjustment of status file with I-130? So in order to apply for the adjustment of status in the permanent resident context, you must apply with a petition. And in most cases, it's going to be the I-130. My husband just went for his citizenship interview last week. After his interview, the IO told him that she will send him a notice because there is a speeding ticket he needs to pay for. But till now, he hasn't gotten the notice yet. For how long will he wait for? So now I would not be able to advise you specifically on this just because I don't know what the situation is. I don't know if it was a speeding ticket or if it was something that was, there are additional charges on top of that. So this is where we would have to schedule a consultation. But with this notice, it's probably going to be either a decision, which is which would be, if she seems to be indicating, it could be a denial, or it could be, if it's not a denial, it would be a request for evidence to maybe submit evidence that you've paid for that ticket. However, another thing that strikes me here is the speeding ticket. Usually with traffic violations, because the whole point of the evaluation is to determine whether you have you have good moral character, and a denial would have to, the officer, in order to deny him on this basis, would have to come to the conclusion that he did not have good moral character. But a speeding ticket should not necessarily cause him to be barred from a finding of good moral character. And so that's where you should get schedule a consultation. Make sure that you understand what process you're going through and what your rights could possibly be in this situation. So great questions so far. I am that is it going to be it for me today. I hope I gave you some useful information. And as I said before, continue to follow me on Instagram. This is where most of my content lives. This is where you'll get the updates. This is where you're going to get all my short, entertaining videos with valuable, value-packed information in those videos. If you would like to get more details, get more information, you can always go to YouTube. I have a channel there. It's the Immigration Attorney channel. Thanks so much for the love. I appreciate it. The Immigration Attorney channel. And that is where you can see replays of lives. You can also see the replays here, but you'll see I do TikTok lives as well. And that is where I post my TikTok lives, as well as other videos that are more, 5-minute to 15-minute videos about different topics in detail in immigration. So thanks so much, Youthful 40, for the compliment. I appreciate it, and I'm gonna keep coming. And yes, big up to Jamaica. I see that flag. So thanks for that, Youthful 40. I will see you tomorrow at 9:30 p.m. Eastern time as usual. And you can come with your questions. I'll come with answers, and I'll come with a topic that I feel is important for you to know about. So thanks everyone. Have a good night. I'll see you tomorrow.